So I'm Shelley Kreitzer-Levy, and first I want to say that I'm very happy to be here and meet this wonderful group of scholars and exchange ideas, and also I want to extend my thanks to the conference organizers. So the title of the article is, as you can see, Deliberative Accountability Rules in Inheritance Law. Now the original title used to be Penalty Rules in Inheritance Law, and as you will see, penalty rules are definitely a source of inspiration, but then I think that they do not accurately capture what I'm going to talk about. So the paper deals with default rules. And inheritance contains, roughly speaking, two types of defaults, right? We have interstate succession, which I'm not going to talk about, and we have gap-filling rules. That when a testator did write a will, but the will is unclear or there has been some sort of change in circumstances, and the law then supplies us with a set of default rules that allow for the construction of the will, and this type of default rules is what the paper is about. Now, the common belief of scholars and practitioners is that these rules should pattern the presumed intent of the testator. So in other words, they should be intent furthering, right? And this rationale has inspired many reforms over the recent years, both in the Uniform Probate Code and in state codes, like in rules of ademption, negative wills, and omitted children's rule. And now, I agree that furthering the intent of the testator is an important goal, but I also argue that alongside these intent furthering rules, there is also room for intent defeating rules in inheritance law. So that sounds a lot like penalty rules, right? Penalty rules following Ayers and Gertner are rules that are purposefully sent as intent defeating in order to encourage the parties to reveal information to one another and to third parties such as the courts. Now, deliberative accountability rules, which is the term that I'm suggesting, are designed to promote accountable and responsible estate planning. So they would encourage the testator to give reasons, design a full and complete distributive plan, disclose information, and generally assume responsibility for the consequences of her will. So my claim is that there are DARs, deliberative accountability rules in inheritance, and there should be DARs in inheritance, and I therefore invite scholars to rethink some of these recent reforms. So let's start by talking about construction rules in general. So the common rationale is intent furthering rules, and we have a couple of main reasons for that. We have saving transactions cost, right? And the basic conviction of law and economic scholars is that these rules, the default rules in general, should be set at what the parties would have wanted in order to save the transaction costs. And in a similar fashion, Adam Hirsch has argued, regarding intestacy at least, that intent furthering rules save the cost of executing a will. So that's one. And this view also finds its support in the underlying values of inheritance law. So testamentary freedom is a pivotal value in Anglo-American jurisprudence. And so intent furthering rules make perfect sense, right? Because they set out to facilitate her presumed intent. So these are the two reasons. So we can see that there are very good reasons for intent furthering rules. Nonetheless, I suggest that trust and estate lawyers and academics must not forget the effect of estate plans on family members and society at large. So now I want to talk a little bit about accountability. So accountability in family property. Accountability in family property is an intricate field. It involves the distribution of wealth, power, and control in the family, as well as relational goods such as sense of belongingness and identity. So I just want to very briefly mention these two. So for one thing, family property reinforces the role of the family in the distribution of power among members of society. So this is a significant social cost that several scholars have written about, for example, Ron Chester here, and it is definitely a powerful institution that shapes the socio-economic landscape. And also, freedom in family property exerts considerable relational and familial influence. This is also a conclusion supported by studies in various fields. So property distribution is closely connected to shaping and reaffirming familial roles. inheritance is considered as communicating judgments on potential heirs, for example. So a bequest can communicate a message of acceptance or rejection and can reaffirm existing relationships. So in short, these decisions in family properties have huge effects on others, be it society at large or their nearest and dearest. So the freedom of the owner may have very good reasons, productivity, well-being, but at the same time it comes with a price tag. So ideally, what we would expect the decision maker to reflect on the possible consequences of her decision and then weigh in the possible benefits and costs of this decision. But she will not always do so. And there are situations, I claim, that create a risk for these negative externalities, for not internalizing the costs of her decision. Okay. So what are these risks? Inheritance deals with death. And that creates a risk of externalities because the owner will not be around to experience the consequences of her action. So the owner does not have sufficient incentives to seriously consider the financial, the relational, and social costs of her decision. And I want to just break it down to three concrete risks. So first, since the property owner never really lets go of the asset, she doesn't have to make the simple calculation we all do when we give up an asset, which is it worth it? Do the benefits exceed the costs? And second, she will not have to endure the resentment of potential heirs. So she does not have to see family disputes turning into feuds. And third, from a social and economic perspective, she does not get to see bad title holders misuse the property, neglect it, or waste it. So we have these three potential risks that she will not internalize the costs, the social and familial costs of her decision. Now, of course, not all testators are indifferent. In fact, many of them really care about their legacy, their family, and their friends. Even so, what I'm arguing is that the conditions of post-mortem donative transfers create the potential for dodging the possible effects of one's decision. So we have a family property, which is a powerful institution, and we have this risk of negative externalities. So what can be done about it? So one solution would be, let's curtail testamentary freedom, which is a solution that has been suggested by several notable scholars in other contexts. But what I want to offer is a more moderate way of dealing with these possible threats to the decision-making process, which are the DAR rules, okay? So the purpose of these rules is to incorporate a requirement of accountability in decision-making process. So, and in the article I discussed the notion of accountability. We usually see it in public or international law. I want to bring it to trust in the state law. So I want to use the concept of accountability to make sure that a state planning process is done in a certain way, that it is cautious, that it includes thought, that it encourages the giving of reasons, a direct statement of one's intention, and consideration of other options. But I really want to stress that I'm not suggesting mandatory rules, right? Or any direct interference with the content of the will. Rather, I'm suggesting easy-to-meet requirements that encourage accountability. So I'm talking about either default rules or what I call rules of form, like you'll see in the negative will example. So rules of form, I mean rules that stipulate requirements regarding the form of the instrument, which are easily met, and leave complete freedom regarding the content of the instrument. So just to show how this will work, I will briefly mention my two examples, which are omitted children's rules and negative wills. And both rules have undergone reforms over the years in many states and in the Uniform Probate Code, and are notorious for being intent defeating. So I just want to ask scholars to maybe rethink these rules. So let's talk about pretermitted heir rules. So the purpose of these rules is to prevent unintentional disinheritance. So these provisions impute an heir when no such heir is provided for in the will. So let's just see the UPC section. So if a testator fails to provide in his will for any of his children born or adopted after the execution of the will, the omitted afterborn or after adopted child receives a share in the estate. And this is not the full section. There are many refinements to the rule, and we can clearly say that this rule is intent furthering, right? So I want to just now review an intent defeating rule. And in some jurisdictions, the code includes any child, even a child born or adopted before the execution of the will. Now, you cannot possibly forget a child who was born before the execution of a will, so the rule is clearly intent defeating. So what I'm suggesting is that this rule is a DAR, deliberative accountability rule. It still allows a parent to disinherit her child, right? Just the default is reversed. So if she says nothing, she will not be able to disinherit. So pretermitted heir rules are designed to give people an incentive to contract around the default rule. And by contracting around the rule, the owner has to reveal her choices and stand by them. So the owner might choose to disinherit, but be unwilling to endure the resentment of the potential heir. So this rule forces her to make an evaluation, positive or negative, regarding certain relatives. So a disinheriting child cannot be just left to assume an error has occurred or my parent just forgot about me. If the testator wants to disinherit these relatives, she has to assume responsibility and reveal her preferences. And furthermore, since the owner has to explicitly disinherit the potential heir, she might change her mind or at least reconsider the decision. So it actually ensures that she will carefully think it through. So we have a rule now that fosters accountability both in a way that it reveals preferences and it possibly reconsider one's decision. So now I move to my second example, which is the negative will doctrine. So a will can include positive and negative provisions. Positive provisions distribute the property. Negative ones operate to disinherit an heir. So if a testator wishes to disinherit some heirs, she will normally name her alternative legatees. When she doesn't do that, her will ultimately contains nothing but negative provisions. And different systems have dealt with negative wills in different ways, yet these provisions seem to have been perceived as problematic dating back to English law. There was some hostility in the past. And the original American rule did not respect negative provisions at all. So this rule was severely criticized, right? Because after all, a negative provision provides just as much guidance regarding the intent of the testator as a positive one, provided there is a set of interstate rules that just fills these gaps. So the UPC, followed by several states, has reversed the rule that it now recognizes negative provisions when the exclusion is expressly manifested. However, I'm claiming that the original American rule is a DAR. So it works to make sure that the owner deliberates over her distributive plan, consider alternative takers, and assume responsibility for her choices. So for one thing, one cannot simply say no in the will, but she has to say yes to somebody else. So if the owner has to name alternative legatees, she will probably also weigh the relative advantages of two possible distributive schemes, right? And she has to evaluate them both. A partial scheme sometimes means she did not fully appreciate the impact of her distribution. So the owner is thus encouraged to arrive at a thoughtful, sound, and reasonable decision, taking into consideration its impact on her relatives. But it's not merely the relational aspect that I'm talking about. Taking into consideration the social impact of family property, the law respects distributive plans as long as they reflect thought and consideration, which is a signal that they carry a benefit for the owner. So even so, I'm not endorsing the original American rule. It was too strict. It ignored disinheriting clauses even when the testator simply failed to appreciate the size of her estate, and a rule that rejects partial distributive plans only if it's knowingly concocted may be more moderate, leads to better results. So where do we go from here? So first of all, more work has to be done regarding the construction of these DARs, And so available construction of the DAOs that I just mentioned are not necessarily optimal. Their effect on the public, drafting practices, or family relations has to be empirically studied. And in addition, we have to consider the effects on layperson's perception of the law. So the rules then have to be simple and clear so that the general public can fairly easily internalize them. I also recognize that both these rules benefit the family, pretty narrowly defined, and it is important to recall that the concept of relational accountability demands a more attuned understanding of relations. So to conclude then, I argue that construction rules should reflect a delicate balance between the intent furthering function, which is clearly the main function, and the accountability function, which may be in the margins, but I think it's still important. So, thank you.
Thanks very much for having me. My presentation and paper are entitled An Economic Analysis of the Uniform Probate Code. And I guess the first thing just to note is, given that that title sounds a little bit ambitious, I'm not proposing in this single paper to do a comprehensive economic analysis of the entire code or all of the provisions. Instead, I want to make a more modest claim that some of the tools of economics and the economic analysis of law may be useful in evaluating the UPC and Will's law, and in particular point to a few examples where in the context of institutional design these lessons might be relevant. So just to start out by noting this little timeline here, and that in the 1960s, although there were many influential developments and movements, I want to point to two in particular. The first one, which we're all familiar with, is the remaking of American succession law that happened, as early as 1962. The ABA and the Uniform Law Commission decided maybe we should look at the model probate code, and they both appointed special committees. But instead of tinkering or revising that, they decided in 1964, the Uniform Law Commission, we're going to have to draft something entirely new. By 1969, as we all know, they published the initial version. Now, at the same time, the 1960s, at the same time, there was another movement that I want to highlight, which is the emergence of this field known as economic analysis of law or law and economics. And sort of one of the definitive papers in this area was published by Ronald Coase in 1960 called The Problem of Social Costs in the Journal of Law and Economics. But there were many other papers later in the 60s and early 70s, Dempsitz, Calabresi, many others, that led to Judge Richard Posner publishing his treatise on the economic analysis of law in 1972. So just kind of interesting that there's these simultaneous developments, but as I'll kind of indicate, they largely emerged independently, and there hasn't been a lot of work kind of looking at potentially how economic analysis of law might be useful in analyzing the UPC and Will's law. Now, there has been clearly a prior literature that has looked at the UPC and the Will's law from a functional perspective. So I want to highlight a few of the main contributions. So obviously, both John and Larry, through a series of articles, in addition to kind of the individual contributions on specific doctrines like harmless error or reformation, one of the main themes of their work is that we need to be looking at the functional aspects of legal rules as opposed to just kind of the formal rule itself, right? So that's one of the main lessons. Before substantial compliance with the Wills Act, there was this kind of excessive formalism that existed, and so John's article, in a way, brought us in a new direction, which has created many developments. In addition to John and Larry's work, there are also economists and people working in law and economics who kind of take a general look at issues of inheritance and the dead hand control, et cetera. So I highlight Posner has a chapter on inheritance in his treatise. Steve Chevelle has 10 pages or so in his book. and there is a large economic literature on the bequest motive as well. More recently, there's kind of been a new generation of people in T&E, maybe most notably Rob Sitkoff, who have kind of tried to apply some of these economic concepts, in Rob's case, agency costs and the economic information, in both theoretical ways. There's also a developing empirical literature with Rob and Max Schatzenbach, as well as some of the political economy issues in a couple of the articles that come to being. But what I want to suggest is that there's actually a gap or hole in which some of the explicit lessons and insights of economic analysis of law may be useful. Now, how does that differ from what the other literatures have done? Well, the new generation of people have focused primarily on trust law. Have not looked as much in terms of how these economic insights might be relevant for the UPC and the law of wills. The generalists and the economists have done some on inheritance, but and this isn't criticizing them in any way, but a lot of times they don't go very deep into the doctrinal and institutional design details, right? So they're not necessarily going to be giving an economic analysis of ademption or anti-lapse. They're kind of at a higher level of generality in their approach. Another example, this whole large economic literature on bequests basically totally ignores the role of trusts, right? The economists just look at lifetime giving and giving at death, but as Rob and Max kind of in a working paper talk about, they ignore this huge issue, obviously, that giving can continue even after people are gone. And how does this, my idea, kind of relate to the contributions of John and Larry? Well, in a lot of ways, it's very much consistent with their work and their proposals, because if you go back and read their many works on it, a lot of them are very much informed by functional thinking and intuitive economic thinking. And this is actually a positive, what they lack is some of kind of the modern jargon, right, which is often unhelpful in kind of exploring these concepts, right? So in a lot of ways, what I'm going to be saying can be used either to formalize what they've said or to validate it, or to explore some of the people who may have criticized some of their ideas and to formalize those arguments, and then to maybe serve as kind of a referee where disagreement and divergences still exist. Right? So I'm just going to kind of focus on 3 economic tools and kind of give a few examples of where I think they may be relevant in analyzing the UPC and laws of wills. So the first one will be transaction costs. The second one would be an ex ante versus an ex post perspective. And the third one would be relying on either rules or standards in developing legal commands. So just to start off, transaction costs. Initial question, what are transaction costs and why are they potentially relevant for the UPC and the law of wills? So transaction costs actually have a couple different definitions. Some people think of transaction costs as the costs of bargaining or exchange, right? So all of the costs that might go into a contract or making a will. Some economists define it actually more broadly as all of the costs of establishing and enforcing property rights, right? So we can kind of think of it as either one of 2 definitions. Now, why are those potentially relevant at all to what we're thinking about in terms of institutional design for the law of wills? Well, here's a few different examples, right? So I guess the first threshold question is, well, does somebody die intestate or do they die testate? And I want to suggest, and this isn't a novel contribution of mine, but the transaction costs are obviously very relevant here. So the cost of executing a will, to locating an attorney, paying the attorney, etc. All of that would be transaction costs. In addition, and this was talked about this morning, just the psychic costs. The person said, well, the surveys show that people would rather have a root canal than to think about what their estate planning should look like. So the psychic costs, the psychic harm, that people don't want to think about death, they want to procrastinate doing it, those would also be transaction costs as well. And so that's why you end up with something like 50% of people dying without a will. In other countries, it's even worse. Right now I'm teaching a comparative UK-US trust and estates class in London, and there it's actually only 40% of people die with will, so 60% of people do not. Another reason, and another way this relates to transaction costs, and actually a little bit to Shelley's reference to penalty rules, it's actually a credit to the fact that we have good intestate provisions that more people don't opt out, right? You could kind of think of a hypothetical in which, well, what happens if we had a penalty rule in which instead of carrying out the intent of the decedent, we said, well, if you don't make a will, all of your property automatically goes to the government or goes to the crown, right? If that was a penalty rule, you might have a higher rate of people making wills, but it's another transaction cost situation. All of these other provisions, default rules are, I would argue in the paper, largely about saving, in addition to carrying out intent, saving transaction costs, the execution formalities, a lot of the gap-filling rules in the UPC. One application that I want to dive into in a little bit more detail is what I call Coase and the non-probate revolution, and I brought a little cartoon here. In addition to kind of the well-known fact that probate involves high costs, and some of the more egregious examples, like John's article about not dying in Connecticut, this is a more recent instance from Harris County, Texas, in which the Houston Chronicle did an expose basically suggesting that a lot of the probate judges are picking the attorneys who appear before them and basically picking specific people and creating more work for them just so there'd be higher fees and costs, right? And so the cartoonist did an accompanying picture. Basically, the probate judges and the lawyers and the accountants are increasing the transaction costs purposely to do this. And so what I mean by Coase and the non-probate revolution is because of these high costs of probate that were well known to at least sophisticated testators and their legal and their attorneys, there was this obviously a huge shift to find cheaper alternatives in the will substitutes to avoid probate, both the costs and the length, the time of it. And so you had this kind of two competing paradigms. You had the public succession system, but you had this private succession system. And typically, when you have this type of competition, the lowest cost provider of the good or service, assuming at least the products are at least roughly equal in terms of quality, will ultimately win. And as we've seen in this instance, far more wealth now passes outside of probate through these will substitutes and non-probate transfers and passes through probate. And what I want to argue is that this is exactly like what somebody, even though Coase never looked at this probate versus non-probate issue, this is exactly what he would have predicted by saying when transaction costs are high, parties can actually bargain around the existing legal rules. So it's kind of a classic case of kind of illustrating Coase's theory, and obviously this has huge implications for the UPC, the rules of construction, the general provisions concerning both probate and non-probate transfers, the development of informal probate, and the provisions that apply specifically to non-probate transfers. Another economic tool that I think might shed some light is the distinction between ex ante analysis and ex post analysis. So what do I mean by that? Ex ante analysis basically looks at a legal rule or policy before the fact, whereas ex post analysis looks at that same legal rule or policy after the fact. And so what I mean by that is, suppose you had, so one of the examples I give to my students in class is, well, why do we have final exams in trust and estates or any other class, right? So I guess one reason might be the signaling function that it provides to potential employers about who's good and who's bad and who might be a good attorney. But another reason, obviously, is to test the material and to give students a reason to study and learn the material. Now, if we just looked at that from an ex post perspective, I might walk in on the day of the exam and say, well, everybody, I'm sure you all did a great job studying. There's no real point now to taking the exam. Why don't we go off and have a big party somewhere? It would be much more enjoyable than you sitting through the exam. It would be much more enjoyable, definitely, than my grading all of these exams, which is a big cost. And so from an ex post perspective, it's sort of like, well, they've already learned what they're going to learn. Why do we have a test? But clearly, when we kind of adopt the ex ante perspective, taking into account what incentives it might provide the students before the class even begins, we see why such a policy would be a very bad rule, right? Because if the students knew that there was going to be no exam, then it wouldn't provide much of an incentive for the students to study. So why is this type of distinction relevant for the UPC and Will's law? So a couple of examples. I primarily want to talk about the dead hand. But so if you look at something like harmless error or reformation, actually, probably most scholarly commentators, I think it's fair to say, would agree that both harmless error and reformation are not only intent-serving, but also welfare-enhancing. So most people agree with that. To the extent that there has been criticism, one of the things that's been claimed is that, well, what effect would a rule like harmless error or reformation have on the incentives of testators or their attorneys before the fact, ex ante, right? Before they probate the will, would that potentially change their drafting incentives? And some people argue, in a couple of articles, they've argued, well, maybe it could. John and Larry in their 1982 piece actually kind of anticipated this argument, saying, no draftsman would actually, purposely or intentionally do this. So they kind of anticipated that objection. And even if we take into account, right, which I think we should take into account, if there was some kind of big effect ex ante on the incentives to draft with a certain level of care, that doesn't necessarily mean that after we do take it into account, harmless error or reformation would be the wrong rule. Probably not. But we should kind of consider all of the incentives there. So the one I want to particularly highlight, though, is this issue of dead hand control, and I want to do it in the context of a bit of an idiosyncratic issue, but I think it illustrates the economic concept fairly well, which is this case that some of you might be familiar with, the Eierman case involving a will provision in which the testator, Ms. Johnson, said that she wanted to destroy her family home at her death. Right? So I actually teach this case in property, not trust and estates, because it involves the right to destroy, but I think it illustrates this distinction fairly well. Because if you think about it from an ex post perspective, it seems totally crazy that a court would enforce a provision that would require the executor to actually destroy the house. Right? So the person, Ms. Johnston, is dead. Why would we want to destroy the house? It seems completely socially wasteful, especially in light of the reason that Shelley mentioned. We might be concerned that even if the person wouldn't have done it during their life because they internalize kind of the benefits and burdens of deciding whether or not to destroy the house, we might be concerned that after they're dead, they're not really concerned about this, so they might do that. But I want to suggest that thinking about the issue just in those terms would be taking the ex post perspective, whereas if we think about it ex ante, there actually might be, and sort of counterintuitively, a reason why a court should potentially enforce the provision, right? We need to take into account of, well, the testator, if it really meant a lot to them, may suffer a loss during life, right? And so if you think of, well, how could this be in the context of destroying a home? Think of an example with personal property, right? So say a Supreme Court justice wants to is very concerned that their conference notes that they took during Supreme Court discussions might be subsequently revealed, right? So if you made a rule, so say if they had a provision in their will saying, my notes need to be destroyed upon my death, I don't want future historians being able to research it, etc. If you didn't allow them to do that, they might suffer some loss during life. They also might destroy the notes prematurely, right? So they might kind of try to circumvent the rule by destroying prematurely, which might be kind of second best situation. They may have less incentive to create the property or take notes in the first place, or it might alter the behavior of the parties in the ex ante. So this was actually one of Justice Hugo Black's concerns, that if there was some possibility that the notes could be published after somebody died, then it might affect the conversations and deliberations of the court while people were still alive, right? So that's not to suggest that we should uphold all these destruction on death provisions. There may be counter arguments, if there's negative external effects on other people, if the value of the property is very high to society after the fact, there might be reasons for not going with somebody's. And so this is just one example, but I think it kind of applies to most or all issues of dead hand control as well, that we need to think about this ex ante versus ex post procedure. The final kind of tool in the toolkit that I think might be useful is this distinction between rules and standards. And this also came up quite a bit in the morning session. I'll be interested. I think Larry kind of reserved a few of his comments about how the drafters of the UPC thought about how much to go down kind of the rule route and how complex to make the rules versus relying on standards. But pretty much the conventional wisdom in economic analysis of law is that there's this trade-off. You could either have a bright line rule, right? So say outside the T&E context, let's set the speed limit at 55 miles per hour. That would be a very bright line rule. Or we could rely on standards. So a standard might be drive reasonably. Right? So it's two very different approaches, and the trade-offs are rules usually involve higher drafting costs. Right? We have to have a committee decide, well, what is the appropriate speed limit, right? Or what is the appropriate rule for deciding whether we're going to acknowledge a will contest provision. Whereas standards, you can say drive reasonably, or we're going to have a reasonable person standard. Very low drafting costs, but then the decision costs are kind of flipped. Usually it might be easier to apply the rule. Was this person going 55 miles per hour, or are they going 65? Whereas standards, you give the courts discretion and they have to apply a reasonable person. It might lead to higher decision costs. Rules are more predictable, whereas standards, people might not know what to anticipate the court is going to do. There might be an agency cost problem where the court might not actually carry out what the legislature meant by drive reasonably. But standards do have the potential advantage that you can kind of, after the fact, do justice in particular cases that the rules might miss because they're over or under-inclusive. So in how does this apply in T&E? Well, there's a couple of really good examples. So ademption. In the 1969 UPC, ademption basically had a rule with 4 exceptions. So it was 2608 with four exceptions. In the 1990 UPC, they preserved the 4 exceptions, added a 5th exception, but then also kind of had a catch-all provision, which is 206A6, which basically also allows a standard for those cases. It might be difficult in advance to kind of specify each exception in which ademption or non-ademption may or may not occur. So if we add a standard, that might allow courts to come in and kind of look at, well, what did the testator actually intend after the fact? Another issue in which this may come up, I kind of mentioned the harmless error and the formalities before. Potentially, there's a question of, well, so we sort of moved from the rule of strict compliance to a standard of harmless error, but there could actually be an argument that, well, if harmless error is correcting every type of problem with attestation, why have attestation at all? So Jim Lindgren wrote a couple of articles about 20 years ago advocating the abolition of attestation, which Pennsylvania has, and with non-probate transfers, there's no witnessing requirement as well. So there might be another situation in which the use of this rules versus standards dichotomy might apply. Should we maintain the harmless error standard, or should we just change it to a rule of no attestation altogether? So my final kind of in-depth application is on the disinheritance of children. So the U.S. approach, and this is just one example, one of the latest examples of somebody who disinherited their child, and I think I have a link to this. So this is Tony Curtis in his younger years, but basically disinherited all of his children and gave it all to his 6th wife. Right? And so in the U.S. rule, this is totally fine. But in most other jurisdictions, they don't rely on a bright line rule. Instead, they have more of a flexible standard, either the family maintenance provisions in jurisdictions like the UK, Australia, and other Commonwealth countries, or China, as Fran Foster has pointed out in her work. They sort of tend toward the intestate share for disinheritance issues, but they give courts broad discretion to kind of come up with answers on a case-by-case basis. So again, I'm not suggesting any one particular answer, at least in this piece, to any individual institutional design issue. All I'm suggesting is that these economic tools may be useful in evaluating the UPC. So in this case, standards may enable the court to do justice in particular cases where a minor disinherited child, let's say one that with special needs, is totally disinherited for some reason. But on the other hand, you can say the rules give greater predictability, and they may have not as high decision costs. But on the other hand, things get complicated very quickly, right? Because even in the U.S., where we have a bright line rule, what is the effect of the rule? It leads to a bunch of will contests, and the will contests themselves have a bunch of standards embedded in them, such as, well, even if you have a no contest provision, there's a standard, well, is there probable cause, right? The UPC says, is there probable cause? And that's a standard. Or even if there is probable cause, then you get to all these other issues in the contest themselves. What is undue influence? Is there a confidential relationship, suspicious circumstances? And so again, you're in a standard world again. But the main point is just to emphasize that some of these economic tools, I think, might be beneficial in helping to pull out some of the points about the UPC and Will's Law.
Myra Bloom, pleased to be here. I want to thank ACTEC Foundation and everyone involved for this wonderful conference, and especially want to congratulate Larry on his remarkable career. I was struck by Larry saying how things changed from, back in the 60s, and you went from probate, focusing on probate, and now looking at non-probate, coordinating. So I want to suggest maybe we change the Uniform Probate Code to the Uniform Succession Code, the USC, but probably that wouldn't go over too big other than in Los Angeles. But I mean,
Notre Dame is playing USC later this weekend. So.
Okay, but I mean, actually, ACTEC used to be the American College of Probate Counsel. So in a way, I think the UPC is much more than a probate code, but in any event. Shelley's deliberative accounting rules I found very interesting, and I think one thing she made clear is that we're looking at intent-defeating rules, but not mandatory intent-defeating rules. So the elective share system, the rule against perpetuities, these are intent-defeating, and the idea is that you can't get out of them. But of course you can when you go to Jonathan Blockmacher's Alaska, or you make testamentary substitutes that aren't covered by a state. So I take it that Shelley talks about default rules. We can change the default, but not simply by expressing the intention to change. And I guess underlying default rules is carrying out presumed intent. So, for example, in the omitted child area, I guess the basic question is, would a testator really want children omitted from a will to take? And I think, in a sense, the UPC says yes if they were after-born. Arkansas presumed intent says yes even if they were born. So I think there's the presumed intent is where we start, and that of course can be disputed. And at least in most states, and I think in the UPC, that don't extend wills rules to non-probate transactions with respect to omitted children, that the default rule is omitted children aren't going to take, as distinct from the wills rule, which is different. So I think that Shelley discussed, she didn't really discuss this, but in the paper at least, she did talk about Arkansas as being sort of intent defeating because intent alone was not enough to change the default rule. Whereas in other states, the UPC, intention is enough to change the default rule. And so in Arkansas, you actually can change the default rule by making a provision or mentioning the child, including by a class. So it certainly is possible to prevent a child from taking. It's just, I think Shelley would like to have it, that you have to do more than just have intent. Intent alone isn't enough. In effect, I think the Arkansas statute is not unusual. It's kind of a Missouri-type statute which doesn't allow intent. And to reveal the choice, that may be important to explicitly do it, but I think it's so simple that I'm not too concerned about it in the sense that all I have to say is I don't intend any children now alive or subsequently born to take. Well, that requires something other than perhaps looking at whether that was really the intent, whether we can get in extrinsic evidence. I think actually an interesting default rule is Kentucky's automatic will revocation statute, which is a lot cleaner to me. So let me just read this one sentence. Kentucky is not in the UPC think about all the possibilities. So their statute, if after making a will, the testator marries and has a child, the will is thereby revoked. So automatic revocation of the will. And so now that clearly is going to require, even if you intended that will to stand, you still have to do something else. So I think that's a good example of DAR. And omitted spouse statutes, which Shelley notes in the paper, can also be DARs. It really depends. UPC has one which is more intent furthering under UPC 2301. By the way, I think actually intestate statutes can be viewed as DARs to the extent that the distribution scheme doesn't carry out intention, that you have to actually affirmatively do something. And I think the UPC actually has its own deliberative accounting rule in 2-609. And this deals with redemption by satisfaction, which is the idea that if you leave something in a will, but you make an irrevocable gift, and at common law, presumptively, that irrevocable gift took away, deemed the bequest to the extent of the gift. The UPC really makes this a DAR by saying that no irrevocable gift in itself will affect redemption by satisfaction, but you need a writing. Essentially, either the donor can have a writing saying, I intend this to do this, or the donee can do it. So that's I think, a DAR, which interesting is a book in my case book, the Zaletsky case in 874, Atlantic 2nd, 411, where the Maryland court was asked to apply the restatement position where someone had made a bequest of essentially $100,000 in value, then during lifetime made a gift to the donee, happened to be a charity, of almost $100,000, and then made a gift of $2.31 to make up the $100,000. And then because the will wasn't changed and because there wasn't any writing, the charity now said, well, we get the amount under the will, and the court said, well, we're not going to extend, in a sense, a DAR rule. We're going to look for intent. And we think the clear intent here was that the irrevocable gifts effectively work an redemption. So I think there are some DARs floating around, and they're kind of interesting. And, maybe anti-lapse maybe the UPC anti-lapse provision is sort of a DAR. They're just simply in the will saying, if I survive, that's not enough. You have to do more. So I think it's an interesting concept that you have to, sort of think about it. And I think there are some rules that are DARs, and I congratulate you on the piece. Now, Dan's piece, I have to confess that law and economics is not an area I had previously delved into, so maybe I wasn't the best person to review Dan's interesting and challenging paper applying law and economics analysis to the UPC. Indeed, when I started looking at the literature, I frequently became confused, got a headache, and also was unclear how economic analysis actually leads to clear-cut results. But I'm comforted that I think Dan doesn't think that's the case, rather that these economic tools can benefit or contribute to rulemaking. And one of the things that Dan did nicely, he summarized the writings, of course, Larry and John's, and explaining the UPC's overriding goal of carrying out donative intent. But what I found interesting is that sometimes donative intent gives way to sort of overriding social welfare concerns, and he talks about externalities. So, for example, the elective share system, in part, is there so we don't have welfare widow or widowers. And I think the rule against perpetuities is justified on society's grounds, and Larry's recent explanation in part about the rule in the forthcoming restatement of property, I think reflects perhaps an externality. And so let me just read Larry's eloquent words. I can't read them as well as he wrote them, but an important reason for... What? No, it's so fine. This is a good day. An important reason for maintaining a reasonable limit on dead-end control is that the limit forces full control of encumbered property to be shifted periodically to the living, free of restrictions imposed by the original transferor. The living can then use the property as they wish, including retransferring it into new trusts with up-to-date provisions. So I think that sort of, without that rule, we have harm to society, and there we go. But of course, Dan's main article is about economic tools to eliminate doctrines by which we operationalize testamentary freedom. And so he went through transaction costs and two others and focused on intestacy versus wills. And one of the things is that 50% of people die without a will. I don't know, Dan, I think that might be higher. But certainly when I ask my students who are still alive, probably 99% don't have wills. So in any event, but you do point out the transaction costs in a will. But I'm not so sure how important that really is, because with the internet, I went on the internet search for making a will. For $59, I can get a complete will, and in other places I can do it for nothing. And the big point is you don't really need a lawyer to do this because it's so simple. So, I think the notion of hiring a lawyer, obviously there's psychic costs involved. And then also the idea that intestacy provides good default rules for the average person, average family. I'm not really sure how you decide who is the average person. I'll just tell you that it turns out Pittsburgh, on average, is the best place to live in the United States. Maybe we should all start thinking about moving to Pittsburgh. But then, of course, we have dysfunctional families where intestacy may not actually provide the right default rule. I don't know a good definition of a dysfunctional family. Maybe one throw out is a group of two or more related people. In any event, even if we like the default rules, one of the things, Dan, I think that's interesting are the transaction costs of guardianship. I was looking at some statistics. There are about 20 million children with single parents, or single custodial parents. They probably have more, there's another parent floating around there. But when each of those dies intestate, in many states, there's going to be the need for a guardian appointed. So that's, I don't know, that's kind of a counterbalance and that's a good reason to write a will. Of course, Uniform Transfers to Minors Act may allow, in certain instances, transfers to custodians in intestacy, but there may be dollar limits. For example, in New York, it's $50,000. So, and again, Paul has statistic about 41% of live births are essentially non-marital children. The intestacy may not, even if it's the right result, the transaction costs are there. Non-probate, I think you do a marvelous job about showing how the transaction costs of probate resulted in the non-probate revolution, which continues with Susan Gary's work, Transfers on Death Deeds. But one of the things also I think that needs to be evaluated are the transaction costs of non-probate transfers. So for example, creating a revocable trust, that's a wonderful thing. Costs money, of course, to do that. That's why we have these revocable trust mills, so people can get people to do something up front. But then the whole notion of funding revocable trusts, deeding property in, there's a lot of transaction costs. And I think John somewhere wrote, I don't recall, the concept of 100 wills with non-probate. I mean, how complex is that? Finding, we have how many Totten Trust, TOD securities, on and on, that the non-probate revolution, I think, in turn entails some transaction costs. It may ultimately be cheaper, but that's there. So then the ex ante, ex post perspective. Well, I knew I was in trouble when I started looking at this in terms of torture. Well, it was kind of torturing, but the concept of torture, there was an article written, was pretty interesting, is whether we should outright prevent torture, assuming there's going to be a ticking bomb. Should we have an ex ante rule preventing torture? Should we have an ex post rule that says in exceptional circumstances we'll excuse we'll excuse this? And it's kind of an interesting discussion. And of course, I looked at a lot of articles where there's all these mathematical formula to evaluate ex post, and I'm not sure that ex ante distinction, I'm not sure that's possible in our field, but certainly there is that thing. So I think your discussion of harmless error was very interesting, and in effect that's an ex post perspective and carries out intent. And the concern about laxity, I think, Larry, John, everyone, I don't think people say, oh, well, I'm not going to validly execute this will because I know that later on, oh, by the way, I might get sued for malpractice, right? So, I think that's a good result. Correcting mistakes, I think that's also a good result. I wish New York would do it in wills, but they don't. But I was confused, you have in your paper, but the idea about correcting mistakes is based on relatively unexplored empirical questions. I'm not sure what those questions would be and what results we'd get from that. The dead hand control, I think that's an interesting question. Again, my question as sort of a T&E person is how do we evaluate whether someone is going to destroy their property during lifetime because they know their wishes aren't going to be carried out. I think you can do it from both perspectives, but I'm not sure ultimately how you evaluate them. And rules and standards, I think, are quite interesting. You talk about, again, protection of children and the idea of kind of family maintenance in other countries. Incidentally, the UPC does have a family maintenance provision, 2-404, which is just during administration, but that also is, to some extent, dealing with, a standard. And the rule, is essentially you can disinherit your children. Maybe another interesting comparison is where the Louisiana forced heirship rule, where either you have to get versus the family maintenance where you might get, those are interesting things. Again, I think some of my friends I used to teach in Louisiana, they talk about simulated sales and other ways to avoid forced airship, so all these rules. And then you talk about redemption and the 2606A, I think it is, or whatever, the provision about getting pecuniary amount even though the property isn't there. And you say that, one of the things about the identity rule is that it's pretty clear, but the identity theory entails significant litigation costs to determine whether a gift is specific rather than general. I never found that to be a really big issue. It's pretty clear. And more tellingly, if you look at 2606 deals with a specific devise. So it only applies once you first classify that. So I think that may be and is false negative the right thing? I mean, I think there's the same issue in either case, whether you have the rule or you have the standard. So, but I mean, in the final analysis, I think my basic question is how to measure costs and benefits in the donative transfer area, and what kind of empirical studies do you think should be done? But I'm sure there's some valuable lessons that can be learned and help in reforms. And it's just, I'm certainly not the person to do that. But overall, I think rules, standards are really a combination of a lot of factors. Philosophical, perhaps economic, carrying out intention, all these things. So I think it may be helpful to get the economic perspective, and I wish you good luck in doing that. Thank you. Okay, so I guess any comments or questions?
No, I just really appreciate all your suggestions, and
Well,
I'm gonna
my pleasure.
think about that.
Up, there's. Okay, sure. One is better than two.
Okay, a question for Dan. If you say that transaction costs are likely to be partially an explanation for the lack of people drafting wills because we have good intestacy rules, so there's no reason why someone wouldn't. This is partly why people don't bother to draft a will.
Well, just if you had worse rules, then you might find more people.
Well, yeah, my question is,
out if it became common knowledge that all of our property is going to disappear.
If we stipulate that the UPC has the good intestacy rules, which is probably the better stipulation to make here, and that the states that don't follow the UPC have bad intestacy rules, do you expect that in states where the spouse is not given as generous a share, they make a distinction between half-bloods and full-bloods, that you're going to see fewer people, or rather more people, drafting wills?
So not necessarily, right? So I think that actually would be an interesting empirical, I'm not an empiricist, but I think that actually would be an interesting empirical question to look at if you could actually find variation. I mean, there is variation across the states to see whether there's any differential. My sort of guess would be that you might not find anything statistically significant, just because I think regardless of the specific intestacy rule has, most people, I mean, they may not know even what intestacy is, or, but most Americans expect, okay, if you die without a will, there's going to be some reasonable distribution of the estate, right? So even though they might not know the particulars, does the surviving spouse take 50% or 100% if all the children are the same? They're sort of banking on the fact that, well, it's not going to be some crazy rule out of left field that sends it someplace else, right? But if there was, if people started talking and said, oh, well, my neighbor just died and all of a sudden the government got all the property or something else that wasn't sort of vaguely consistent with their intent, then you might actually see more people. But I just want to actually clarify, and this is also a little bit responding to Ira's comment, I wasn't saying that overall that would be a good thing if fewer people made wills. There's many good reasons to make a will, even if kind of you're totally satisfied with the distributive provision. So I wasn't sort of advocating, let's get that number down because it shows that we're doing really, good in designing transaction cost savings rules. But I just think that was just one spot where they come up.
I just had a question just in terms of methodology for Dan, and it was raised because Ira said something which made me sort of question some of my assumptions. We always assume that standards are more costly, right, than rules. So, and I mean, just in sort of evaluating this, I've always thought that, but do you take into account when you analyze transaction costs about a bright line rule, the cost of avoidance? And Ira, what you were talking about in Louisiana just raised that question for me. So it's purely sort of a methodological question, Dan? So if people are doing sham sales to get around forced airship in a bright line rule, how do we account for that cost in thinking about the fact that we normally say, oh yeah, bright line rules, easy to administer, low transaction costs?
Right. No, that also, I totally agree that would need to be taken into account, right? So you're right, that traditionally the conventional wisdom is rules, higher drafting costs, lower decision costs, standards flip. But yeah, I mean the cost of enforcement, right? So I guess either people circumventing it, but usually when you have circumvention, then you have some type of enforcement or plugging the stat. I mean, the whole history of estate and gift taxation, a lot of it is, well, okay, people are avoiding it somehow, so we have to enact a new rule, et cetera. So that definitely, I mean, and that's one of the, especially when you have sophisticated estate planners, I mean, if you create a rule, you might think it's the best rule in the world, but people are going to find ways to attempt to circumvent it, right? So that, I agree, that would need to be a cost that's taken into account. And I think sort of economic analysis of law would be totally with you that, yeah, we can't ignore that piece of the puzzle as well.
Paula, the rule that you posed is an intent defeating rule, and so therefore people will look for ways to get around it. In the UPC, mostly in the UPC though, we don't have many intent defeating rules, and mostly intent effecting or carrying out rules, and we're very mindful of the difference between rules and standards, and we go on the assumption that standards probably have a better chance of reaching the, quote, right or just result in a given case, but at a higher cost because you have to litigate or at least engage in settlement, whereas rules are bright line rules. Now, what's the disadvantage of bright line rules? Over-inclusiveness and under-inclusiveness. Okay. Can you strike a balance where you can draft rules that have the advantage of bright line rules and yet minimize the over-inclusiveness and under-inclusiveness? And that's what we try to do. And that's why a lot of the UPC new provisions are more complicated. That's why. And so that was our theory on that. Now, some people will disagree with that. They don't like more complicated statutes. I don't think, and I think John mentioned this in the luncheon talk, I don't think the complication of the statutes really impedes enactment. For example, one of the most complex statutes in the UPC is the anti-lapse statute, right? I talked to a lot of bar groups, and people would come up to me afterwards and say, the statute's not that complicated when you work through it, and that's not the problem. Now, another thing is when you think about the UPC and the more complicated rules, and I guess that is the most, I believe that is the most complicated in all of it. Think about it from a different standpoint. Think about it from the standpoint of somebody who's got a case and a judge who has a case, not from the standpoint of, well, I'm a law professor and I got to teach this stuff. And people, students say, look at it, and it's, difficult to look at. I tell my students, before we go into the anti-lapse statute, don't read the statute and try to figure out what it says. think about a case, and then work through the statute and see if it gives you, the result that you think would be the result that the testator would probably approve. We can't know for sure because individual testators are individuals. And then the second thing is, does it spit out an answer? And most times that statute stands up under that way of looking at it. One thing that I forgot to mention this morning, and I do take a little pride in this, there have been very few appellate cases interpreting the UPC. But other than that, that was a good presentation, I think.
Okay, well, I guess, so Larry, Boris Bitger, a tax person, used to say he never reads the Internal Revenue Code section unless the legislative history is ambiguous. So maybe that's a way to read the comments and then, right, yeah.